Mr. Speaker, with your leave, I rise to make two brief announcements that affect this honorable House and my capacity as Attorney General. Mr. Speaker, I wish to bring to the attention of this House that last Tuesday, the High Court of this land set down a momentous decision in which the claimants in two cases that were joined were able to get judgment in their favor against the Speaker of this honorable Parliament, the former Speaker, and with the Attorney General as a party intervening. Mr. Speaker, these two matters that were before the court began in 2013, April 2013, following a period when the leader of opposition, the then leader of the opposition, the Honorable Mark Brantley, had filed with the clerk of this honorable Parliament, Mr. Jose Lloyd, who was now retired, a motion of no confidence in the government of Prime Minister Denzel Douglas. That motion was filed on the 11th of December 2012. And for some 26 months, Mr. Speaker, your predecessor, the Speaker of the day, refused to have this motion tabled, brought to the floor of this House, and debated. It was a period, Mr. Speaker, a very dark period in the history of our country. It was a period, Mr. Speaker, when our Constitution was dragged through the mud. It was a period, Mr. Speaker, where right-thinking people in our country cringed at the way in which the government of the day totally ignored our democratic process. Mr. Speaker, the judgment has vindicated those who have always felt that it was their right, to bring a motion of no confidence in order to have peace and good government in our country. For 26 months, Mr. Speaker, 6 members, 6 elected representatives of our National Assembly sat on the opposition benches and identified one of their members as the person to be Prime Minister. 5 members of elected members, Mr. Speaker, a minority, sat on the government benches, and for 26 months, Mr. Speaker, this country was governed by a government that took millions of dollars from our treasury to do various things in our country. And we question the legitimacy of such a government. For 26 months, Mr. Speaker, that government took millions of dollars to pay lawyers, to prop them up, and to extend this case so that they could have impunity in running this country. And so, Mr. Speaker, it is for us, as citizens of this country, to hail this judgment, this momentous judgment, as laying down the foundation of our democracy. And so, Mr. Speaker, I would want to commend the judgment and read into the record paragraph 3 of the judgment of Her Ladyship, Madam Justice Pauletta Lands, High Court Justice of St. Kitts and Nevis. After consideration of the parties' arguments and for the reasons that follow, the court concludes that every elected member or elected representative in the National Assembly has an implied right under Section 52, subsection 6 of the Constitution of St. Christopher and Nevis to bring a motion of no confidence and to have that motion listed, debated, and voted on without undue delay and within a reasonable time. I also conclude that this court has jurisdiction and that the rights which are implicit in Section 52, subsection 6, had been violated by the failure of the Speaker to schedule the motion of no confidence for debate and to be voted on without undue delay and within a reasonable time of the motion being handed to the clerk or sent or left at the clerk's office. Finally, I conclude the court has jurisdiction under Section 96 of the Constitution to grant relief for that violation and that the claimants are entitled to the declaration sought except those which the claimants are no longer pursuing because they are now academic. Mr. Speaker, Her Ladyship concluded by saying that an order that the defendants pay costs to the claimants and each of them, such costs be assessed if not agreed within 21 days of today's date. And I say again, Mr. Speaker, that this judgment is a vindication of 6 of our elected representatives: the Honorable Mark Brantley, Dr. the Honorable Timothy Harris, Honorable Eugene Hamilton, Honorable Sean K. Richards, Honorable Vance Amory, the Honorable Sam Condon, that these 6 representatives of the day have been vindicated in this country by this judgment. And it lays down the rule of law as it should be in our country. If a motion of no confidence is brought to the floor of this parliament, it should be debated. We should not be held captive by a government that is not properly constituted. And so, Mr. Speaker, I just want to make that statement to this Honorable House.
Very good, very good.
I would like to make a second statement to the Honorable House, Mr. Speaker. And this statement has to do with information that has been gathered by this government.
Yes.
This government has information that the member for number 6
Yes.
of this Honorable House had been issued, has held, and has used a passport of another country, of a foreign country.
Yes.
We have evidence that the member for number 6 has a diplomatic passport that states in it that he is a Dominican national. This government, Mr. Speaker, would like to place on record our very deep concern that someone who has led this country for many years and who still sits in this parliament should hold a passport of a foreign country. And we say, as that result has shown an acknowledgement of allegiance, that he has shown an acknowledgement of obedience and adherence to foreign state. This is what our Constitution says, Mr. Speaker, as Section 28, subsection 1. A person shall not be qualified to be elected or appointed as a member if he is, by virtue of his own act, under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. Section 31, subsection 3, provides that, Mr. Speaker, subsection 3, an elected or appointed member shall vacate his seat in the Assembly, subject to subsection 4, if any other circumstances arise that if he were not a member would cause him to be disqualified to be elected or appointed as such by virtue of subsection 1 of section 28 or of any law enacted in pursuance of subsection 2, 3, or 5 of that section. Mr. Speaker, this government is deeply concerned that we should have someone who sits in our parliament who is in a position to be disqualified. And so this government has sought advice, legal advice. This government puts to this House that we will be approaching, we have begun proceedings to go to the court under section 36 of the Constitution, which I'll read for the benefit of the Parliament. The High Court shall have jurisdiction to hear and determine any question whether any person who has been validly elected as a representative was qualified to be elected or has vacated the office or vacated his office. An application to the High Court for the determination of any question under subsection 1B or 1C may be made by any representative or by the Attorney General. And if it is made by a person other than the Attorney General may intervene and may then appear or be represented in the proceedings. And so, Mr. Speaker, I would want to bring it to the attention of this Honorable House that the Attorney General has initiated instructions to Senior Counsel to bring proceedings in this matter to determine whether the member for number 6 should vacate his seat or not.
Yes.
Thank you. May it please you, Mr. Speaker.
Stay up to date with news, programs, and activities of the government with SKNIS. Like us on Facebook. Listen to us on SoundCloud. Follow us on Twitter. And watch our videos on YouTube. Connect with us today. SKNIS, St. Kitts and Nevis Information Service.